Pick up where we left off, and we were talking about Senate Bill 142. We had the proponents already provide testimony, and then neutral was providing at the time. And do you want the reviser to review that a little bit, or should we go ahead? Senator Peck.
Thank you, Mr. Chairman. I would be curious as to hear what the reviser has to say about what our conferee mentioned.
Okay, Tamara, why don't you take it from there and update us on Senate Bill 142.
Thank you, Mr. Chairman. So as you remember from yesterday, Senate Bill 142 would allow the Secretary of Wildlife, Parks, and Tourism to promulgate rules and regulations to specify the types of approved personal flotation devices. And there was a fiscal conferee yesterday who did, in his testimony, suggest an amendment to the statute. So on line 12 of the bill, it says these personal flotation devices are required for children 12 and under while aboard or being towed by such vessel. His testimony suggested an amendment to substitute the word aboard for the word underway, or underway and not in an enclosed cabin. And I will note the federal regulation on personal flotation devices does require either an appropriate personal flotation device approved by the Coast Guard, or if the child is below decks or in an enclosed cabin. So whatever the committee's wishes are with that, I'll be happy to assist.
All right, thank you. Any questions for Tamara on that? Senator Peck.
So thank you, Mr. Chairman. So you said that the federal guidelines or Coast Guard guidelines now are that a child has a flotation device on at all times while on board. And I'm sorry, you said something about being below decks. It sounded like even below deck they should.
So the federal regulation says that the child has to either wear the personal flotation device or they have to be below deck or in an enclosed cabin. So while they're below deck or in the enclosed cabin, they do not have to wear the flotation device.
Okay. Well, Mr. Chairman, with that explanation, I'm comfortable because I was thinking about the duck boat situation in Branson a few years ago. Some of those persons, because my dad's a chaplain with the hospital over there and he had firsthand conversations with them, it appeared that some would have been better off to have not had a device sucking them up against the bottom or something. But so again, I appreciate that. I think I'm good to go now. Thank you.
Okay. Thank you very much. That was a good observation. We want to make sure we get it right. And thank you, Tamara, for clarifying that for the committee. Any other questions on the, so we will make that an amendment. We're going to save the government some paper expense if we can just do it by a voice vote and a proclamation since we're only changing one word. So I will make that amendment that we change aboard to underway on that report. Senator Francisco.
I will make a substitute amendment.
All right.
That we substitute aboard and not in not in an enclosed cabin. So I think we heard from the Department of Wildlife and Parks that they still have concerns about children under 13 just being on the boat itself. I think I'm not clear when it talks about underway, if you've stopped and you've anchored in the middle of a lake, that still seems that you would want to have some protection for children. So my motion would be to say aboard and not in an enclosed cabin. But we would certainly want the reviser to make sure that that works.
Okay, Tamara, you want to comment on that? To that substitute amendment?
If I'm understanding correctly, Senator Francisco would prefer to mirror the language in the federal regulation regarding an exception if the child is below decks or in an enclosed cabin, but leave the word aboard.
That's the case, and so if it's more appropriate to also say below deck, I'm happy to add that, and that may make that more clear.
Senator Dahl.
I'd like to second your amendment.
We have a substitute amendment on the floor right now.
Okay, but we never got the opportunity to work your amendment. I'm just,
I think we can do them both if we, the committee wants to. Senator Francisco.
So my recommendation to you, Senator Dahl, would be to vote against the amendment that I've made, and then we would be back on the other motion.
Okay, everybody understand that? Well, everybody in favor of the substitute amendment, signify by saying aye. The substitute amendment, which Marcy did. Oh, okay. Okay, sorry about that. So seconded by Senator Ware. All in favor of the substitute amendment, signify by saying aye. Aye. Opposed, no. Say the measure has failed. Back on the original motion. Senator Dahl.
I second your amendment.
Okay. I need to make it over again? Okay. Senator Ware, discussion on that.
Yeah, my concern is that our point is child safety, and child safety doesn't start and stop with the boat engine or wind power if it's a sailboat. It doesn't compute to me, but, okay.
Any other, Senator Francisco?
Thank you, Mr. Chair. So the other testimony that I understood was that there was a risk if someone is in an enclosed cabin being held by that flotation device against the ceiling and not able to escape. So I'm wondering, if you share that concern, would it be a friendly amendment to say aboard and not under deck or in an enclosed cabin? Because then we would at least not have that situation that we've made it more difficult for a child to escape if there is something.
Okay, Senator Alley.
Not aboard, underway.
Thank you, Mr. Chair. For clarification purposes, could we have Tamara repeat what the Coast Guard language is?
Tamara, reviser.
Certainly. So the federal regulation reads, no person may operate a recreational vessel underway with any child under 13 years old aboard unless such child is either wearing an appropriate PFD approved by the Coast Guard or below decks or in an enclosed cabin.
Senator Francisco.
Thank you, Mr. Chair. So I'm saying if we use the word underway, then the boat has to be traveling. So it's not the situation that it's tied up against the docks. But we are mirroring the understanding that it could be dangerous below decks or not in an enclosed cabin.
Senator Alley.
For clarification purposes, I would like to make a motion that we adopt the federal regulations as our guideline.
Is there a second? Senator Peck? Motion been made and seconded to adopt the Coast Guard guidelines, federal guidelines?
Federal regulations.
Federal regulation.
I said Coast Guard earlier, but it's federal, I believe, what she said.
There was a second. Any discussion? Senator Francisco.
So I understand that wording, and so would just like to hear from the reviser. Would that be a change in this? Would we have to reference those Coast Guard guidelines? And if the guidelines change, then our regulations would change?
The committee can do it either way. If I reference the federal regulation specifically, it will have to be as that regulation exists on July 1, 2021. And so you would have to just be mindful of any updates to that. The other thing I can do is that language that I read to you, I can just place that language in the statute as your language.
Everybody understand that? Senator Peck.
Thank you, Mr. Chairman. I really like that. I think that is important. And with the clarification, because I was thinking we may not need this language in Kansas statutes if it's federal regulations, but because of what the revisor just indicated, they could change federal regulations, then our guidelines would change. So, yes, I'm thinking that Senator Alley's motion to just put that into the federal guidelines into the bill.
Okay.
It's okay. Thank you.
Any other discussion on the Alley amendment? Senator Staub. Oh, okay, Tamara. Reviser, you have something?
I would just like to clarify if Senator Ali's motion is to specifically reference the federal regulation number or to just use the language that is in the federal regulation.
Senator Alley.
I would like to use the language that's in the regulation as of 9:15 today.
Thank you.
Okay, everybody understand that? Any other questions? Hearing none, all in favor of that? Senator Alley's amendment, signify by saying aye. Aye. Opposed, no. Motion carried. Thank you, Senator Alley. Committee, we'll move on. We were with the neutrals, and we heard their testimony, which we were talking about. Are there anybody else who want to testify neutral? Any other proponents? Any opponents? Seeing none, we'll close the hearing on Senate Bill 142 and proceed on with the next item on the agenda, Senate Bill 143. We'll start with the reviser. Tamara, would update the committee on where we're at on the Senate Bill 143.
Thank you, Mr. Chairman. Senate Bill 143 would amend several public warehouse laws relating to grain storage. First, the bill addresses definitions that are in that law. The grain warehouse statutes are currently organized in a way that does have a specific definition section, which you can see is section 1 of the bill. But then there are also a number of definitions that are kind of scattered throughout other sections in the grain warehouse statutes. And you can kind of see those in the stricken language of the bill, starting at the bottom of page 6. There's a couple on page 7 and on page 8 as well. So Senate Bill 143 would place all of those definitions that are scattered about in the one primary definitions section. There are no real substantive changes to those definitions. There are no additional definitions. This is primarily an organizational change to the grain storage law with regard to those definitions. So then the second change in Senate Bill 143 is when an applicant submits a financial statement with their application, an audit is also required to be submitted. Those audits can currently be conducted by an independent certified public accountant or an independent public accountant. The bill would strike the option for an audit from an independent public accountant, so only CPA audits could be submitted with that financial statement. Additionally, Senate Bill 143 would update fees relating to the grain warehouse program. There is a fee chart for storage fees on page 5 of the bill. The Secretary sets the functional unit fee and the storage fee in rules and regulations. The functional unit fee cannot exceed $500, and the storage fees cannot exceed those fees that you can see there in the chart. Additionally, Senate Bill 143 would amend the examination period for each warehouse. Currently, the Secretary is required to examine each warehouse at least once during a 12-month period. The bill would extend that to an 18-month examination period, and the bill would take effect upon publication in the statute book, and I'll be happy to answer any questions.
All right. Thank you very much, Tamara. Committee, any questions for the reviser? Senator Peck.
Thank you, Mr. Chairman. So on the definitions on page 5, or not definitions, I'm sorry, but it's changing from annual fee to storage fee, and this might be for the agency, but does that change the time frame? Annual is 12 months. Storage could be a long time, more than 12 months, right?
I would refer to the agency on how they're to address that.
Okay, thank you, Mr.
Okay.
Chairman.
Randy, you want to respond to that? Or either whoever's, okay. Come forward, state your name and who you represent. Welcome to the committee.
My name is Jeff Vogel. I'm the program manager of plant protection grain warehouse at the Kansas Department of Agriculture. That was some clarification we were making in that statute. Is initially when it talks about assessing the fee, it's on an annual basis, but it also referenced annual throughout that. And so in an attempt to kind of clarify that it's a storage fee, we eliminated all those annuals that were listed through that paragraph, even though initially it states that it was assessed on an annual basis. There also, later on in the statute, gives the secretary the option of assessing the fee depending on the length of time that the license is being issued. And so that is why those annual references were removed, is to make it more consistent, because currently the statute is a little bit inconsistent with referencing annual versus storage, but it is an annual license fee.
Okay, thank you very much. Any other questions? Well, thank you, Tamara, and we will move to our first proponent, Mr. Vogel. Would you come back? Get a little exercise there. And welcome back to the committee.
Thank you very much, and good morning, Chairman Kirshen and members of the committee. As mentioned, I'm Jeff Vogel, Program Manager of Grain Warehouse Program for the Department of Agriculture. And also with me in attendance is Kelsey Olson, Deputy Secretary for the Department of Agriculture. The Grain Warehouse Program doesn't very often come to the forefront of conversation, but it does provide an important service to Kansas farmers. Because of that, I want to provide a brief background that helps explain why we are in the situation we are. The current program came to the Department of Agriculture in 1997 when the old Grain Warehouse Department was split up with the grain grading program going private. That's the Kansas Grain Inspection Service currently, and the Grain Warehouse Program that regulates grain warehouses that store farm grain coming to the Department of Agriculture. The program currently licenses 67 grain warehouses in the state with over 550 million bushels of licensed storage. We license these grain warehouses to ensure that they meet financial, bonding, and insurance requirements. In addition, we conduct annual examinations or inspections to ensure the bin, what's in the bin, matches what the books are. And that's a very simplified explanation of what we do. There's other statutory requirements that we check, but mostly we are making sure from a grain perspective what they have in storage matches what's in the books and that they're not short or have sold farmer-owned grain. Fiscally, the program has struggled through the years with budget shortfalls to fund the examiners needed to complete these annual examinations on a statutorily required frequency. In our written testimony, there's a chart provided that helps explain over the last 10 fiscal years the revenues, the expenditures, which are on the bar chart, and then the line graph that's overlaid on that shows the carryover funds from the Grain Warehouse Fee Fund that help fund these deficits in the last years. This year, during our budgeting process, it was determined that this fee fund carryover was going to be exhausted at the end of the fiscal year 2022 with current revenues and expenditures. So during our budgeting, so throughout our process, we wanted to find a solution to these annual deficits. We consulted with stakeholders to come up with all possible solutions to this problem. Even though there is a federal licensing program for grain warehouses, that there are grain warehouses in the state that are licensed under USDA, several advantages to continuing a state grain warehouse program were cited in continuing this program, including better customer service, KDA's willingness to license bunker storage, and an examination process that gives the grain warehouse a complete measurement of their grain during our examination process. With that understanding, we pursued many different options in trying to come up with a solution to adjust fees for the first time since 2004. Those include looking at just adopting the federal fee structure with maybe a smaller functional unit charge, charging a functional unit fee across all locations, a flat bushel fee where every bushel of storage was just charged a certain amount, and other options. Senate Bill 143 contains the agreed-to proposal that we discussed with stakeholders that keeps the existing fee structure in place, but raises the bushel charge. That is the chart that you see in the bill. Depending on the licensed storage of the entire grain warehouse, there is a bushel charge assessed. This increase, or this change, will adjust fees or increase fees for all licensees, no matter their configuration or size. That's as compared to some of the other options I shared, where there was a lot of variation on the effect on an individual licensee, where some actually received a substantial decrease and some received a substantial increase, depending again on their configuration. So the total increase in fees that's being proposed is 38.5% on an average basis for all grain warehouses, but varies on an individual basis, meaning that it does affect individuals a little bit differently depending on their configuration. Table 1 in our written summary helps explain, kind of at a summary level, the number of licensees, their size, and the fees that will be collected under the proposal in Senate Bill 143. Increasing this maximum fee will allow the program to generate enough revenue to eliminate the budget deficits, maintain 6 examiners in the field, and allow replacement of our aging vehicle fleet as needed. I do understand that this committee has discussed the additional state general fund allocation to the program by $60,000 that will, in previous meetings. That would allow us to commit to be fully staffed with 6 examiners sooner, but with the legislative process of increasing fees and collecting additional funds at the time of annual renewal, that could take between 9 and 18 months. So any additional allocation of state general fund money will just allow us to move forward quicker. And we want to assure everyone that any allocation of SGF would be we would offset any fee increases by the month amount appropriated. So finally, as the revisor mentioned, there were several other changes. Most of them were clarification, but I do want to point out that updating the requirement for the annual audit or review to be done at a CPA level will ensure that the fiscal reports that we receive to calculate net worth, which is a very important license requirement, will be done with a trained and certified public accountant. In addition, changing the examination interval from 12 to 18 months, our goal would to keep the 12-month schedule, but it will allow us for flexibility in the case of unexpected events that might come up that might delay our arrival. So in closing, I want to, Senate Bill 143 will allow KDA to operate a grain warehouse program with a sustainable budget to protect farmers, and I'm happy to stand for any questions at the appropriate time.
Thank you, Jeff, very much. Committee, any questions for Mr. Vogel? Senator Alley.
This question probably doesn't have a lot to do with what you just went over, except what do we do with, or how do you figure in the grain that's stored outside under the tents? How are those figured in?
So we do give the option for grain warehouses to license bunker storage, particularly ones with fixed structures or sidewalls that have coverage and aeration. There are math techniques we use to measure that grain and to ensure the calculation of that is correct, and we match that against the books. So there are our grain examiners will throw tape over these piles and in fact take measurements and use very complicated, at least in my perspective, complicated math to come up with the correct volume to give us a right estimate in those particular cases.
Any other questions, committee? Senator Peck.
Thank you, Mr. Chairman. So I want to make sure I got an understanding here. It's not going to be an annual fee. It's going to be a storage fee of up to 38.5% increase average. And then on page 6, the frequency of the inspections is going to be changed from every 12 months to every 18 months. But yet there's still going to be an annual fee. So if it's that schedule, for example, figuring 2 18-month period is 3 years. So rather than having 3 inspections during that time, a grain warehouse could have 2, but they're still going to pay an, quote, annual fee, storage fee. I'm sorry, I'm not, the timing's not all meshing for me.
I understand. And so, yes, it is an annual fee. The fee that's collected is based on the storage of the grain warehouse and the number of functional units they have. And combining those two gives us the total grain warehouse licensing fee that's assessed on an annual basis. It's annually, it depends on the fiscal year that grain warehouse operates. We will continually issue licenses and renewals through the year. But to your question about the examination interval, our goal is to keep a 12-month examination process, but adjusting the statute to 18 months would give the department some flexibility in the unexpected events that might occur, just like COVID-19 impacted our schedule with conducting annual examinations that we're continually trying to catch up with, at least at this point. So that looking at that part of the statute, our goal as a program would be 12-month intervals, but it will give us some flexibility in the event of unexpected events.
I understand the goal of 12 months and the current personnel, but if we put this in statute, future personnel may read that as we only need to do this every 18 months.
You know, and then that's a good question. I do, you know, our intent is to keep that because we do not want to upset the balance of conducting 12-month examinations and the service that provides to the grain warehouse and to the farmers to ensure that grain warehouse is conducting business like they should be.
All right, thank you, Mr. Chairman.
Any other questions? Senator Francisco.
Thank you, Mr. Chair. So I'm having, I think, some of the same trouble understanding license fees and storage fees. Where in this bill does it say that those will be assessed annually?
Apologize for the delay here.
Jeff, why don't you just find that?
I can-
We'll move on to the next proponent.
Okay,
We'll
thank
come
you
back
very
to you
much.
while you look for that.
We will do that. We will.
Okay,
Thank
terrific.
you very much.
Next online is Randy Stuckey from Kansas Grain and Feed. Welcome back, Randy.
Thank you, Mr. Chairman. Good morning, members of the committee. Randy Stuckey, on behalf of the Kansas Grain and Feed Association this morning, we do stand as proponent to this bill, Senate Bill 143, and we've had a more full discussion on the request out of SGF for the $60,000 in the previous weeks for the committee on this issue. That in fact, we do stand in support of Senate Bill 143 as it stands, as it's before you today, but knowing that we hope that the $60,000 from SGF in 2022 would help offset some of this increase, that about $120,000 a year. Let me start off by saying that we do support the state grain warehouse program. Clearly, there's a federal program under the USDA that any grain elevator can choose to go to the federal program they find validity in the utility in the state program for various reasons that Mr. Vogel mentioned. So we do support the program as it stands today and going forward. We want to help the agency out with their budget deficit, as that fee fund is being exhausted and will be exhausted very soon. So for that reason, this bill probably needs to happen in order to pay for all the inspectors that KDA says they need for this grain warehouse program. There are various facets to the bill. We want to say that we appreciate KDA coming to our industry and the Cooperative Council last fall, laying out the numbers for us and saying, look, this is what we're looking at. What's the best way to solve this riddle? And they did. Jeff Vogel worked tirelessly in putting together various ways that we could achieve this objective. We think this is the most fair way. It just takes the current fee schedule, tax on and increase. The increase to the storage license capacity fee alone that's being amended is actually about 84% on that fee schedule. You add that to the $500 functional unit fee, and together, that's an increase of about 38%. But alone, that schedule that we're talking about is about an 84% increase. So for the grain elevators, it's a substantial increase. That's why the $60,000 we think makes sense as a more reasonable increase in a given year. Now, that being said, we think the work that's been done by KDA on this bill makes sense. There are a lot of other changes that you see in the bill as well. These were supposed to be technical cleanups. You see a lot of strike through and text. That was because a lot of the definitions apparently were scheduled or scattered throughout the act. And this was intended, we were told, to bring those in one part of the bill, one part of the statute to make it more user-friendly for both KDA and the regulated industry. So I think that's all we have to say really on the bill, but we'd stand for any questions at the appropriate time.
All right, any questions for Randy? Senator Pack.
Thank you, Mr. Chairman. 84%. 84% increase. Would we not be better off to reduce the increase and then KDA, if they can prove a need, come back to us again in 5 years or something for an additional increase? Because I'm going to guess they're not going to increase it to the maximum. Would that be your understanding?
Right, so, and I don't want to step out of line, Mr. Vogel, but
I know I'm trying to create friction here. No.
yeah, no, what we've been told is that this change creates a new cap in the statute, and that KDA will then pursue a regulation the following year, knowing what their budget's going to be, what their expenditures and their incoming monies is going to be. And based on that, they'll establish that fee schedule in regulation. So if they receive the $60,000 SGF, that will be reflected in the next year's, first year's regulation set for that fee schedule. The next year, they'll do a different regulation and another regulation for that, reflecting that fee schedule based upon their expenditures and their receipts then. So if we receive that $60,000 from SGF, it won't be the full 84% increase in that license storage capacity fee. We certainly hope that it won't. It's thousands of dollars on some of these members already because it's, as Mr. Vogel said, there's 67 companies, right? And so to establish and uphold an entire program on 67 companies, even $120,000 is a big lift. But that's where we are.
So you don't necessarily have a position if it would be better if we reduce the increase now, but give them an increase and then ask them to come back. And I realize that through rules and regs, they're supposed to come to the legislature. But, and I'm not trying to put you on the spot, honestly, I'm not, but.
We've told the agency that we'll support the bill and in hopes that we'll receive some SGF increase because it's really a very large lift on the industry without it. So we'll support the bill this time.
And my last question, Mr. Chairman, is if 1 year there is SGF put in to keep the fees down, but then the next year there's not, and it goes up, but then the following year there is, do the fees historically go up and down, or pretty much once they're set there, that's where they are?
Well, they have a fee fund, so if there's some overage, it'll go back into the fee fund, and they can work that out in the regulations going forward, in the carryover.
All right, any other questions for Senator Francisco?
Thank you, Mr. Chair. So Randy, do you have any comments about the examination periods? How often is it important to have these examinations made?
Thank you, Senator. And that's a good point. I should have mentioned in my initial presentation, but that was something we actually asked for, knowing that the USDA doesn't necessarily follow a 12-month protocol. So to have parity with the federal system, we don't need to stay to the 12 months inspection cycle. I would imagine the Farm Bureau and many of our members also would like the 12-month cycle. But if we can move to something broader than that, if that helps save costs within the agency, most of our members, I believe, would be okay with moving that 18-month cycle. Twice every 3 years, once every 18 months.
Senator Francisco.
So you are seeing this as a change in the cycle, not necessarily just allowing the department some leeway if they haven't come in exactly 12 months.
I think when we brought the idea to the agency, that we saw this as a way to maybe save some money on a program that's clearly stressed for funds. How they employ that is up to the administrative decisions of the KDA.
Go ahead.
Thank you, Mr. Chair. So I think later we'll have a question for the department is if they did adopt an 18-month schedule, could that result in some reduced costs for those elevators?
Any other questions? Seeing none, thank you. Oh, Senator Straub.
Thank you, Mr. Chairman. Having worked at a grain elevator, I'm assuming that this works in coordination with the scale inspectors or weights and measures inspectors. Are those inspectors paid through state general fund, or are those inspections paid for through state general fund?
Well, I don't believe that the scale inspectors, that's the weights and measures program, which may be an overarching program of the.
I see Kelsey shaking her head.
But I don't believe that those scale inspectors, those are pretty specific techniques that they do, both large and small scales. They don't perform the grain warehouse inspections. That's a separate team.
Right.
And I can't
They
speak
work
to
in
the-
coordination with each other, because if your scales are off, it might say that you have less or more grain than you actually have in storage. So then when your warehouseman comes and measures what you have in storage, that's where, I suppose that both inspectors play a part in providing accuracy to what is actually there. Am I wrong?
I'll defer to the agency.
At the department.
Sorry.
Kelsey, come on. See if you can help with the question. Welcome to the
Good morning,
committee.
Chairman and members of the committee. I'm Kelsey Olson. I'm with the Kansas Department of Ag. Our programs do interact with one another. So if our weights and measures program is at a facility that they see a large impact on the scale, they would certainly notify that to the grain warehouse program, because certainly there is overlap. And that's something why our weights and measures division tends to focus on those large scales, because of the large impact that they have to the industry. So I hope that answers your question.
How are those inspectors through weights and measures paid? Is that through fees, or is that through state general fund?
So there is what's called the PIF fund, and I will get the acronyms incorrect, I'm sure. It's a petroleum fee inspection fund, and there is also some licensing funds that go along with that, and we use SGF in that program as well. So it's kind of a combination.
That was exactly my question. Thank you.
Any other questions for the department? Seeing none, our next proponent is here Stafford, or, yeah, there you are. Welcome back to the committee.
Good morning, Mr. Chairman and members of the committee. I'm Shahira Stafford, and I'm here representing the Kansas Cooperative Council. I don't have a lot to say other than what Randy said, just to say that the KCC is in agreement with that position. The KCC was involved with discussions with the KDA and Grain and Feed early on throughout this whole process, and so we do stand in support of Senate Bill 143. Something I just want to point out, 30 of the 67 state licensed elevators are cooperatives, and a lot of them are smaller cooperatives. And so while we do stand in support of a reasonable increase, the members that we have that are licensed by the state They do so because they see value in the customer service that they get from the KDA, having someone local as opposed to being regulated by the federal government. Those are all benefits. And so we definitely don't want to see that state program go away. We support the existence of both. And our members appreciate having that option like we've historically had. Having said that, we've talked about that 80% increase. That can be a significant hit to a lot of our members. So we do ask for your support when the time comes for that $60,000 SGF increase to mitigate the impact on some of our smaller cooperative members, because that really can be a strong hit, a big hit to them. I don't think that I have anything else to say. Again, we appreciate the KDA coming to the industry, asking our input and working with us. They've been very flexible and trying to come up with something that the industry is comfortable with. And so we support this bill. We just ask that maybe some SGF funding gets increased just to mitigate that impact on our members. So I'll be happy to answer questions.
Okay, thank you very much. Any questions? Senator Francisco.
Thank you, Mr. Chair. Do you also have any comments about the 18 months or the 12 months annual inspections? And I'm sort of just thinking to myself, you know, I know that grain arrives at the warehouses and grain is shipped out. So if you have an inspection program throughout the year, does this help balance? If we did it every 18 months, would that help balance the timing for some of those inspections?
So this is something that we put out to our KCC membership early on, the specific proposal of increasing it from 12 to 18 months. And I would say the majority of our membership are okay with that. If that would kind of decrease costs, that they were comfortable in giving that cap of 18 months, you know, if it's closer to 12 or if it's 18 months, that was okay with our membership.
Senator Straub?
So, thank you, Mr. Chairman. I was just checking to see if you found the page number in the bill that says the language. It's on page 6, lines 11 through 14. It says the secretary shall examine each warehouse operated by a licensed public warehouseman not less than once during each 18-month period. Does that satisfy what you were thinking?
I heard from the testimony from the department that they were still planning to have annual inspections, and this was only to give them some flexibility. I heard from some of the other proponents that if you did it 18 months, we could actually reduce the costs of the program. Perhaps we would need 1 or 2 fewer inspectors because of the number of inspections that needed to be done. So I think those are 2 very different directions. One, are we just giving some flexibility to the timing? And the other is, can we help reduce costs overall by having a longer period? And I'm probably familiar with this because we talked about how often we have inspections with the Pet Animal Act for about 6 years.
Thank you. Senator Straub.
Thank you, Mr. Chairman. In response to Senator Francisco's concerns, I absolutely understand and agree with you to save costs, but knowing, you know, harvest schedules, it's important to have scales balanced and everything checked annually. I think if you get off of that annual schedule, you create an opportunity for much more inconsistency, and you could have a larger problem if you wait for that 18 months. And it says in that bill, after that, it says, but examinations may be conducted more frequently as the secretary determines is necessary to protect the public. So I agree with the language that's in the bill, and I understand that the department feels like a 12-month schedule is what they will maintain. This just gives them some leeway.
All right.
Mr. Chair, I'm not arguing one way or the other. I'm just asking the proponents of the bill to help me understand what we're looking for.
You want to respond to that, or are you through?
Yes, I think that it would be up to the agency to determine whether or not moving to the 18-month schedule, or if they plan to, first of all, and then if they do, if that would reduce costs, and if the industry would see a reflection in that reduced cost on our fees. But again, our membership has stated that they are in support if that does extend to 18 months.
All right, thank you very much for the committee. And next we have John Donnelly, Farm Bureau. Welcome to the committee, John.
Thank you, Mr. Chairman and members of the committee. I am John Donnelly. I'm here today on behalf of Kansas Farm Bureau. I am always extremely reluctant to stand up and give Me Too testimony. However, on a fee increase bill where we are supportive of the fee increase, I think it was appropriate for me to stand up and say why, as we are the ultimate, all costs get passed down to the farmers and ranchers, as we all know, so we are the ones that eventually will pay this. No one likes fees, no one likes taxes, but no one likes fraud. And this program is here to help protect us from having fraudulent actors in this marketplace. So this is an extremely important program. It's an extremely well-run program. We are fully supportive of the activities that this program has done in the past. We appreciate Mr. Vogel and the department and their willingness to have these conversations with us prior to bringing this to you. And that is the work that you see in front of you. Specific to the question on the 12 to 18 months, I think it's language that all parties, quite frankly, can live with. While we may have a different perspective on what it does, I do think it allows for the potential for both scenarios to take place should those discussions take place, and we don't have to bring that back to you necessarily the next time we have to have these discussions. I also want to say we appreciate the $60,000 that has been put in through the SGF. It kind of goes back to the we don't like taxes, we don't like fees. We also know that the grain warehouse program is not really real high on the radar of budgeter of the governor's office, Republican, Democrat, whomever, when they create budgets, and we've seen that over the last decade with funding. That's why we have a fee fund balance that has went low. We've put less state general fund dollars in over the last 10 years. So, and I throw that, I don't know if that's the accurate amount of years, but I think you get my point. So this bill is necessary to have a functioning program and to protect the farmers and ranchers from potential fraud that's out there, or potentially out there. We think the program does a good job, and I will stand for questions.
All right, any questions for John? Seeing none, thank you, John. On the proponents, that's all we have for proponents. Jeff, did you have a final remark, or would Senator Straub's point is made? Come on back to the bill.
Thank you very much. On the question about the 18 months and saving, we've not run the numbers on actual savings because our intent is to keep 6 examiners and conduct examinations on a 12-month routine. Furthermore, what complicates this a little bit from our perspective from having enough of a workforce is that some of our licensees are so large that it requires all of our examiners to be there for sometimes 4 weeks or more to conduct the examination, and any reduction in staff would just prolong that visit with them and make it more difficult to conduct the examination and do the appropriate work. Thank you.
Okay, thank you very much. Senator Fagg.
Thank you, Mr. Chairman. Mr. Vogel, this is a question for you. On page 5, when you look at the storage fees, I just wondered what the thought process, when you go between each one of them, some of them are $40, some are 60. Did somebody just scratch through that, or is there some thought that went to that?
I understand. And so the table was adjusted, all the levels were adjusted by a particular percentage, which was basically 83.5%, to come up with the total revenue we needed to eliminate the deficit. And so those numbers that were there to begin with were what were in statute, and it's hard to understand the intent of the legislature when they passed the maximum fees years ago and set this as the standard. And so the agreement we finally agreed to was just to increase those by an even percentage across all the levels. Yes.
Thank you, Jeff. That's all. Committee, are there any other proponents that we've talked to? Is there anybody else that wants to talk as a proponent? Anybody else for a proponent? Are there anybody want to testify as neutral? Are there any opponents that want to say something at the committee today? Not seeing any, we will close the hearing on Senate Bill 143. And committee, we have a few minutes left. We're going to talk about fish and have the secretary on Senate Bill 160 come forward. But first, we'll have Tamara, the reviser, tell us what it's about. Tamara?
Thank you, Mr. Chair. Current law establishes the minimum value of fish and mussels at the value listed for the appropriate fish or mussel species in the guidelines of the American Fisheries Society Special Publication number 30. Senate Bill 160 would update the reference to those guidelines from Special Publication number 30 to number 35. You can see that change at the top of page 2 in line 2, and the bill would take effect upon publication in the statute book. And I'll be happy to answer any questions.
Good job, Tamara. Thank you very much. Any questions for the reviser? Not seeing any. Thank you, Tamara. Was you about to say something there? Or okay. No. Thank you very much. We will turn to our first proponent, and we'll call in the Secretary of Wildlife and Parks, Mr. Lovelace. Welcome back to the committee.
Thank you, Chairman Kirsch and members of the committee. Senate Bill 160 seeks to simply update the fish and mussel valuation process for illegally commercialized wildlife. This isn't for normal citizens. It's for people that are trying to catch this and then sell it for commercial reasons. The bill deals with updating the valuation process. The American Fisheries Society publishes guidelines for determining monetary restitution for values for fish and mussels that are illegally taken. This is applicable, again, in Kansas only for illegal commercialization. The current guideline and statute uses Special Publication number 30, which was enacted in 2003. The department is requesting to change to Special Publication number 35. The most current version of that was in 2017. Importantly, in my testimony, you'll note that prices don't always go up. Some things are cheaper to replace now than they were back then. For instance, for the walleye listed in my testimony, the prices actually go down. So this isn't necessarily just trying to get more money out of people. In general, though, prices do go up over time if you're taking channel catfish or many species of sunfish. They have gone up, but not always. Very simple change, and with that, I would stand for questions, Mr. Chair.
Okay, thank you, Brad. Questions for Mr. Lovelace? Senator Francisco.
Thank you, Mr. Chair. So how often is the manual updated?
Every few years by the American Fisheries Society, and we just follow their guidelines because they're uniform across the United States.
So then this may be a question for you or a question for the reviser. Why would we not identify the most current version of the manual rather than a specific version?
So I would ask that of the reviser. Yep.
Tamara, you want to comment on that?
Yes, thank you. So anytime the legislature refers to another body or another entity's document, you are essentially delegating your authority to say what those, in this case, what those values of those fish and mussels are. And so if you just left it at a blanket or continuing reference to the most recent publication, that would be an unlawful delegation of your legislative authority.
Thank you very much, Tamara. Any other questions for the Secretary? Seeing none, thank you very much. Brad, thank you for coming. Are there any other proponents for Senate Bill 160? Are there any neutral testimony? Seeing none, are there any opponents? Seeing none, we will close the hearing on Senate Bill 160. And committee, takes care of our work for today, so we are adjourned.